And this is about inheritance. Right. The Supreme Court says all children, whether born within or out of wedlock, are entitled to an inheritance. And this is a matter that had emanated from the Catholic court, going all the way to the Supreme Court. Now, the Muslim leadership in the country has come out to say, no, the Supreme Court has crossed the red line. They called it the red line. The Supreme Court has crossed the red line and has gone beyond that. We have with us in the studio an advocate of the High Court of Kenya, who is a seasoned lawyer, but also has served in various capacities in government. Also, he's Muslim, Murshid Abdalla. He is a former commissioner with the National Police Service Commission, the first commission. He is also a former commissioner with the Interim Independent Boundaries Review Commission. He and others in the Andrew Legale Commission are the ones who created these boundaries that we have today that are supposed to be reviewed by the IEBC. And IEBC is time bad, but those are not the things we'll discuss. We'll discuss the matter of inheritance. Murshid, good morning.
Good morning to you.
Karibu sana. Good to see you. It's been a while since you last appeared on air.
Indeed.
Yeah, but it's like riding a bike.
Yes. Yes.
So to welcome you to the conversation, Janet is going to give you the day's quote, and then we shall listen. You shall listen to it and tell us how you interpret it yourself.
Okay. Sylvia Tamale, that's the person who did this quote today. She's Ugandan. She's a pioneer in many ways because she was the first female dean at the Faculty of Law at Makerere University. Now, the quote was, "We must decolonize not just the law, but the mind, the body, and the desire." We must decolonize not just the law, but the mind, the body, and the desire.
Now, yeah, I would compare that with the problems we have in Kenya today. That we have a constitution. We don't have constitutionalism by all state organs, be it the executive, the judiciary, or parliament, be it the citizens ourselves. So for us to really get to this constitution, which you're going to discuss today, you've got to be with that value of having constitutionalism, which is open to the spirit and the tenor of this constitution. Yes.
Yeah, that's really well said. Because I think embracing the constitution and the constitutionalism comes from trying to draw that link of decolonization.
Yes.
It has to be a full reset of embracing what's in front of you.
Actually, what we have here in the constitution, to just sum it up, it's a tool of decolonization.
Right.
Yes.
That's good. The constitution is a tool of decolonization.
We're decolonizing our systems, be it judicial, legislative, or is it executive. What we are seeing in our country today is the fight against what we need to get rid of, and that is colonial relics.
That's
yes.
Colonial relics.
Absolutely.
Nice one. Murshid, on Monday, the Supreme Court delivered a judgment on a matter that had been taken to it. And the long and short of what we have seen in the news is the Supreme Court has said that even children born out of wedlock are entitled to an inheritance. And this is with regards to a case that had emanated from the Catholic courts.
Yes.
But you're the advocate, please. And I'm sure as you prepared for this conversation, you went into both broads. What is this case? Where did it start? And what were the merits and demerits of it?
Okay. This was a case whereby a Muslim died intestate. And if you die intestate as a Muslim, meaning you didn't leave a will, then you are bound by the Islamic principles and doctrines regarding inheritance. And there is no piece of legislation anywhere in the world which comes close to the minutest of how a Muslim's estate can be shared between those who are entitled to the share. With one exception, a Muslim has a right to testamentary disposal of his property. That is, before he dies or she dies, we can allocate as far as 1/3 of our estate to whomsoever we want, for whatever cause you want it to be. And the other 2/3 must devolve according to the principles of Islamic law as set by the Creator himself. So in that 1/3 demarcation, you can demarcate even to those of your children whom you had out of wedlock, if you so wish to do so. You can allocate it to anybody else with one condition, that it cannot be demarcated to an inheritor, because those are entitled to the 2/3. That is if you wish to do it. Other than that,
that must be in writing, though.
What in writing? Yeah, yes. No, a will can be in writing. A will can be oral. Whichever way you do it, you have to have witnesses. But then, that one is what is prescribed under the Islamic Sharia on matters of inheritance, and it is cast in stone. It's not subject to any further derogation or interpretation, because in our body of law, we have the Sunnah. The Sunnah means what was practiced by our Holy Prophet and his companions in order to give reason and meaning to what God has prescribed. So if we go out of those parameters, it means we are no longer abiding by the Muslim faith. So this is a matter of faith. It is a matter that it was legislated upon by the Creator. So for a Muslim, and I'm happy what you said, what was said by the Supreme Court, that was the Supreme Court. It's not the Quran, it's not the Sunnah. So for Muslims, that is right, and the religious leader were right, that they have overreached that red line.
Okay, before we get there, yes. You started by telling us how the case first happened. So
now in that case, I'm going back
died.
Yes. So in this regard, this gentleman, the deceased, had a first wife. She was Muslim. And we're not talking about religion here, whether she was Muslim or Christian. It doesn't matter, because Muslims can marry Christians. So he died, and she had a number of issues. She went to the Qadhi's court, because that is where the jurisdiction is, and applied for her to be the administrator and administering the estate. And as far as she was concerned, it was between herself and her children. A few days later, a lady who was also a wife of the deceased, she also went to the High Court with the same application. And she said she's the sole beneficiary, together with her children, which were born from the husband. Now, she said she became a Muslim after about 10 years of cohabitation. And in those years of cohabitation, she gave birth to children with the man she was cohabiting with. The fact that she became a Muslim later on is of little consequence. You don't have to be a Muslim for you to be married to a Muslim. So it's superficial. But the way it is couched, and that's why we want to demystify, it's like as if there is a clash between some Christian issues and Muslim issues, and the conversation out there, if you look at the social media, there is that misunderstanding which went with it. So, when she went to the High Court removed the matter from the Qadhi's court, consolidated, and made a finding, and the judge in that respect said that this is going to be done according to the Islamic Sharia on inheritance, because the person who owns the property is a Muslim. And that is an exception given in our constitution, that whenever you are determining matters under the following aspects: Muslim personal law, personal status, inheritance, divorce, as well as marriage, it has to be done according to the Islamic Sharia in respect to those aspects. And for all intent and purposes, any jurisprudence behind it, any reasoning behind it, has to be in tandem with the Islamic Sharia covering those aspects. Again, we have to go back to the historical context of it, because that is where I believe, and many people believe, that the Supreme Court erred. It did not go back into the historical context. When the Portuguese came, they were the first European colonizers to the shores of East Africa. I'm talking about the 10-mile coastal strip. They found a system in place. We had a jurisprudential and a legal system in place like all Muslims do anywhere in the world. So when they came in, they tried to impose another legal structure on the people who were living and existing at that time, and that is us. For 500 years, they stayed there and failed to have any impact on Muslim personal law. And they exited. Subsequently, fast forward came the British. When the British came, they learned from the earlier colonizers that we can have certain arrangements of organizing these natives, but we cannot organize them on Muslim personal law. So they respected the jurisprudential and the legal system which was existing before their arrival. And if you go again fast forward, when independence came, this country was an entity which was divided into three. There was NFD, North Frontier District, predominantly Muslim. There was the Coastal Strip, predominantly Muslim. And then there was the Kenya colony. When the British came, they respected what they found there pre-existing. And they did not impose their Judeo-Christian interpretations to the Muslim personal law and status. And that remained. And as a condition, one of those which was to bring the three entities together between PM Shamte of Zanzibar and PM Jomo Kenyatta, there was an agreement that it is subject to the Muslims being respected in terms of the very same things. And that is why it found its way to the first constitution. And in 2010, despite all those pushing and pulling, it is there. And that is why we have that exception, which, by the way, it's a tight exception for Muslims on the Bill of Rights, on the question of equality, insofar as it comes to personal status, inheritance,
And
marriage, and divorce. And again, it was, even before a reconfirmation, it was there in the former constitution. The Law of Succession Act exempts till today clearly, Section 2, that all the provisions of the Succession Act, which was in question here, would exempt Muslims. And if we are to apply it to Muslims, it will be in accordance with the Islamic law on inheritance. So that is the position.
So the second,
Yeah.
I just want to come, just looking at the chronology, because I think it's important for everybody to understand what's this case about and how do we end up here. First time, one wife goes to Kathy.
Yes.
Second wife goes to High Court.
Yes.
High Court says, all right, so superior jurisdiction, bring them all together.
Yes.
High Court says we shall follow Sharia.
Yes.
Who took it to the Court of Appeal?
Court of Appeal was taken by the lady who didn't want that Sharia to be applied.
Second one.
You know why? Because according to Islamic rules of inheritance, any child that was begotten outside of wedlock has no entitlement when it comes to inheritance of the father. And that is what the Islamic law is. So she went on appeal saying that she is not accepting that one because she relied on the other things about equality, children's rights, which were enshrined in the Constitution. But all that for Muslims will turn around the exception which was kept, that when you are going to make a ruling and a finding on Islamic inheritance, the law applicable for all intent and purposes is the Islamic law on inheritance. And where do you get that law on inheritance? It is in the Quran which is akin to the Bible, and it is to the traditions of the Prophet as they practiced it and elucidated it to us.
Yeah.
So any deviation outside of that one is not ruling it according to the Islamic law.
Is that unique to inheritance when it comes to Islamic law and the Constitution?
Yes.
Inheritance. Is it unique to inheritance in terms of what can be, where the law can be applied vis-a-vis Islamic law? Or are there other matters that it's like, no, even if you bring it to the Supreme Court,
yes,
whether it's, beyond inheritance, is there anything else that...
In every other matter, we are ruled by the laws of the land, by the Constitution. The only exception which was given was on personal status for Muslims. Inheritance
What does personal
for
status
Muslims.
mean, by the way, Murshid?
Personal status is what I am made of. It is an evolving law. It is about the set of values and cultural principles that surround me. That is my personal status. You see, there is a whole body of jurisprudence out there. And if you want, we can have another program for us to describe and unpackage what is personal status. For your information, Muslim lawyers had set with the judiciary concerning this aspect of personal status because it related to the custody of Muslim children. And it was some kind of a working agreement was arrived at. But unfortunately, for purposes we don't know much, it is gathering dust. If that was brought forward, the Muslim personal status would be better understood, and erroneous rulings like the one we are seeing today from the Supreme Court would have been avoided.
Right. We'll get into it, but then I wanted to know now how this coexists, because the exception is made in law, but then there's the structure of the judiciary as well that has, your Supreme Court, Court of Appeal, High Court and Magistrates Court, which is where the Qadhi's courts fall. So then I'm assuming that's when this case escalated beyond the High Court and to the Court of Appeal, that was then overruled. So if an exception is made in law, but then the court that makes the ruling has other courts above it, how do these two things?
Okay, what you are trying to say is that in the judicial hierarchy, the lowest court is the magistrates court, and that is where the chief Qadhi resides. There are courts which can go on appeal and further appeal to the Supreme Court. That is what we're saying. But insofar as the jurisdiction of the Qadhi's court on those 4 items, it is governed by the Islamic law on those items. So regardless to when it goes on appeal, when it goes on appeal, they look at matters of law, matters of procedure and all that. But it has to be leaning on what the Islamic Sharia talks of. Even if it goes to the High Court, you have to make a ruling based on Islamic principles. You cannot go out of that one. Even as it goes to the Court of Appeal, it is superior in terms of hierarchy. It is not superior in terms of the interpretation and the law itself. Yes.
Okay. What about a case where one of the because I'm trying to see a situation where if the child or children who are born out of wedlock are not Muslim, but they do still want to claim an inheritance, the person whose inheritance is being claimed is a Muslim. How then?
You see, the question here
whose property
was not about that one. The question is the inheritance aspect of the property of a Muslim by persons who were born out of wedlock. Let me make it clearer. Even if I, God forbid, was to have a child out of wedlock and I am a Muslim and the mother is Muslim, even if I am subsequently to marry her, it doesn't change the aspect of the inheritance of the child out of wedlock. So it's not a question of this being a Christian issue or Muslim issue, or the wife being a Christian and the husband being a Muslim. That only added certain coloration to the effect that when the judges were sitting, they were trying to unpackage and to bring some thinking which is Judeo-Christian in character to something that was principally Islamic jurisprudence, which was protected by the law of the land, through legislation, and by the Constitution, which is the supreme law of the land. And for our information, even the Supreme Court, even the judiciary is bound by the Constitution. And I'll take you back to Article 1. Yeah, that is the sovereignty of the people.
Let's take a break, Murshid.
Yes.
We'll come back. It's an interesting conversation because we are getting to unpack this and to understand the genesis and also to understand the law and how the law then acts. Murshid Abdalla is an advocate of the High Court. He's a Muslim. And he's been a commissioner in various commissions, the Boundary Review Commission, the National Police Service Commission. But let's talk about what he's here to do today. He's a lawyer. We'll be back in a moment at 29 minutes after 7 to continue with this conversation.
Day. Some quick feedback from YouTube. Maimuna Mwidao says, I'm glad that Wakili has explained the issue clearly. Please add that even if the woman married but had conceived before marriage, the child remains illegitimate. Okay. Zafania Achapa says, the fundamental question is what happens when Muslim personal law conflicts with the provisions of Bill of Rights? And I think that's what we're trying to unpack here. Khalid says, I believe religion is yet to be understood. The shift underlined needs a strong core that's not to be brainstormed. And so on and so forth. So quite a number of people, I think, also learning about that intersection as we continue the conversation.
Yes.
So maybe you could explain to us how the exception in the Bill of Rights is made as far as now inheritance. How is that structured in law to make exceptions within the Bill of Rights?
You see, Islamic law and jurisprudence did not start with this constitution or with the current batch of Supreme Court judges. It pre-existed Kenya. It pre-existed British colonization and the Portuguese colonization. It has a 1,400 years of history, and it will continue doing so till the end of this world for us Muslims. The issue is very, very simple. That body of jurisprudence has been recognized. There is no otherwise to it. It has been entrenched in the Constitution as an exception to all these things we are talking about. The equality which is otherwise Judeo-Christian, jurisprudential in nature, and it's confined only, in our case, to these 4 matters. It doesn't go beyond that. It doesn't go to criminal law. It doesn't go to other civic law, transfer of property and all that. The thing is this. Let's reflect on it much more clearly. We do remember S.M. Otieno's case.
Yep.
You might remember it.
I might remember, but there are many people who do not know.
Who do not remember it. So it was a situation whereby S.M. Otieno, a prominent lawyer, left a will that when he is going to die, he will be buried on the preferences of his wife in Upper Matasia. Even he put it down in writing. After he died, there was a contest between the wife and the clan, the Umera Kagere clan, that nothing doing.
And the wife was Wamboi.
Yes, despite his wishes, it will demonize the clan and the cultural values that we hold dear. And it was made according to the rights of the Umera Kagere clan. It was done under a different constitution, one which was even more restrictive. This one is expanded, and that is the law which is subsisting to date. That is cultural. You can imagine that this is now religious. There was no will which said otherwise. It is made there. We are citizens, we are sovereign. Judiciary, parliament, and the executive works according to the will of the sovereign. And we have a pact, we have a constitution in place. So are we saying, therefore, despite all these provisions, I can sit with Judeo-Christian lens and jurisprudence and look at Islamic principles and give my interpretation to it on the basis that there are certain side things which have been exempted. Yeah? And if we go by that, You know what is happening in Scandinavia today? Because of the same thinking of our Supreme Court. They have started and they have kept a law and a custom that a mother can be married to her son. Yes. And that the father can marry his daughter. That is there in the Scandinavian law today as an interpretation of this liberal, secularist thinking. I can see from the way you've pulled your face.
No, I'm
Janet,
just curious. Yes.
You've pulled your face because it is repulsive to the African tradition, to Muslim tradition, to mainstream Christian tradition. I'll put it to another scenario. If we agree to these gymnastics that were done in the thinking and the delivery of this judgment, we'll go there and we'll reach there. As Kenyans, will we agree to those gymnastics? Obviously, the answer is going to be a firm no. Another example I will give you, that Catholics, the Catholic Church, you marry in the church as a Catholic. There are certain things, conditions to that marriage which attach to you, because that marriage now has a certain parameter to follow, one of which very clearly is that you have to abide by monogamy. You cannot have another wife, and if you do have that other wife is not recognized under that institution, and it becomes bigamy as a criminal offense. How can that be right? And you say that Muslim one, which you can modify with certain mental gymnastics, and say that now this, I am ruling, that this is what must be applicable to a Muslim, which is protected, and which we have the sources of our law being the Quran in that aspect. And it's for us, it is the commandment from God. The enforcer is God himself. And you think that that Muslim can abide by that law. It's a choice for Muslims. Do you want to go Supreme Court? Do you want to go by law? And no Muslim will go to the Supreme Court way. Which brings the question of enforceability. You cannot interpret a law and their rules of interpretation for it to become an absurdity. This is certainly an absurdity. Yeah? And what if you come to the enforcement part of it, you cannot do a law and say that is... You can enforce it. You cannot, for example, a couple going to the court and saying that this husband of mine is not giving me my conjugal rights. So the court makes a ruling, you must do it 2 times or 3 times a week. How are they going to enforce it? So it's the same thing. But the other thing is, if you say, therefore, that a Catholic has to abide by monogamy, that must be respected. A Muslim's marriage is done by polygamy, and it's restricted to 4 wives. African tradition, there is no limit as to how many wives you can take. So there is a respect of everybody's cultural values, more importantly, religious values. And what I think has happened today is a complete disregard and disrespect of people's cultures, people's belief, which are enshrined in the Constitution. Even the right to worship. When you are Christian, I'm Muslim, they're Hindus, there's a Hindu Marriage Act, they have their own conditionalities under Kenya. Muslim Marriage Act, we have our own conditionalities. There is the Christian Marriage Act, there is the Traditional Marriage Act. They all have their own specific terms and conditions. And even if you go to the preamble of our Constitution, where we say we are going to respect diversity and all of those things.
Then it goes against
and then we have certain rights about religious beliefs and religious rights. And we need to live in harmony with that one.
But with this ruling setting legal precedents, how does it then begin to affect succession disputes? Future succession disputes, especially in the Muslim community.
And that is precisely why we said the red line has been crossed. Because for sure, there's no Muslim who is going to make a choice of the Supreme Court in front of the laws which are there by the Creator, the Quran. When we die, we're not going to meet a Supreme Court judge there to judge us. It's going to be the Creator. So that is the powerful item. When you hear that the Muslim are saying, the Muslim cleric are saying, they've crossed the red line. Indeed, they have.
But maybe let's look at it from the positive side, Murshid.
Yes.
The fact that it has gone to this level and elevated conversations this much,
Yes.
it's also a civic education moment
Yes.
for Muslims.
Yes.
Right? That they now know, by the way, if you have been ignoring the matter of writing a will, if you have children or other dependents who
Yes.
are outside of wedlock,
Yes, yes.
the way to secure the inheritance is by making sure that you have a will
Yes.
that then allocates you the 1/3 that you can divide among them. So the 2/3 then comes to your legal other dependents. The positive side here is that there's a lesson to be learned.
Let me tell you,
even
Eric,
within this-
before you go,
This-
let me intervene on that one because I lose it. You see my son there.
Yep.
If you ask him about this thing, he will tell you exactly what the position is. We learned this in madrasa.
So he already knows.
He already knows. But it's that aspect of somebody's weaknesses as a human being that, you know, tomorrow I can do it.
Mambo ya kupuuza.
After 2 years, I'm still a young person. You know, you can die in the lift while going down here.
Yep.
Yeah. So you're right in saying that. And I want it to be a cautionary issue. Number one, first of all, as Muslims, we need to remain true to our faith. Cohabitation, extramarital affairs. You are given the opportunity if you want to go marry 4 women. I mean, what's the problem? Why do you have to cohabit? Now, even if because of your frailness, and everybody is frail, you do that. But then that does not take away the fact that there are certain repercussions, certain rules, and certain regulations. Not only that, are we aware that even if the father was to inherit the son's property, in Islamic law it is allowed, but in this instance, he wouldn't be able to do so because the child is born out of wedlock. The child has no responsibilities over inheritance to the father. Do you know that the wife in this case, what we may say, okay, she's Christian and all that, she has a right of inheriting the husband's property because she is a wife just like any other woman, even if she is a Muslim. And her kids now can inherit from her. This case and this cohabitation started in 2000. You can just calculate the age of the kids. All this while, the father had this responsibility of looking after the child according to the law and everything and give them a good upbringing. And if he was, like you're saying, a person with foresight, he could have left something under the will. It wouldn't have been touched.
The 1/3. I wanted to ask about that because in a situation where someone, a Muslim, practicing Muslim, does write a will, but then they apportion more than 1/3 to children that were born out of wedlock, what then happens?
Okay, the ruling would be you claw it back to that 1/3 and redistribute.
And redistribute the rest now to the children.
To the children.
Okay.
Yes.
I want to use it very loosely, legitimate children.
Yes.
Okay.
No, please. Children born out of wedlock.
Children born out of
the
wedlock.
illegitimate person is the father.
That's
not the
thank you. Thank you. That's why
Because it protects
illegitimate parents.
Thank you. That's
but
why
this is a child born out of wedlock, and that is the manner in which it was addressed in the Quran and in the tradition.
So that they don't bear the weight, right?
Thank you. That's why I said loosely, but you've given me the better terminology. Then now it brings a question that Eric had asked during the break of now, jurisdiction. Who has ultimate jurisdiction? Because now if we go to the Supreme Court, it's still under review. It's gone to the, it's still under review. Then what next?
If you're asking me if the Supreme Court has jurisdiction to hear matters from the Court of Appeal, yes. Does the Court of Appeal have jurisdiction to hear matters from the High Court? Yes. And likewise, does the High Court have jurisdiction to hear matters under the Qadhi's Court? Yes. And if you talk about jurisdiction, what is the jurisdiction of the Qadhi's Court? Matters pertaining to this,
Only.
protected by the law. Go on appeal. The appeal will be subjected to the conditionalities which are attached to it and the protections thereto. Go to the further appeal, all the way to the Supreme Court. So they have jurisdiction.
In all of them, they'll have to follow what is in Sharia.
In the Sharia. And I wish that pain was taken to understand Islamic jurisprudence, bring in, because the Supreme Court and any other court has the ability to call in. They have the personnel, they have the resources. But not doing that wasn't really the right way to do things, especially in a matter so touchy. If I were to remind you, in the 1970s, probably me and Eric were just born at that time, in the 1970s, Muslims, there was a law which says that everybody must undergo post-mortem. And there was an agitation to that one. And Muslims were given the exception. You don't have to undergo post-mortem because according to us, you die now, by lunchtime you are forgotten, buried. That's it. That's what the law says for us. Now, not only that, the only exception is where there was some criminality and there's some court and you know you have to put in evidence and all that. That is allowed. In the 1990s, the Succession Act came in and it subjected everybody to the same Succession Act. Agitations began and the exception was made because that was in line with even the existing constitution then. So after having done all that, and repeatedly having the same result. I don't understand how the Supreme Court decision thought it will overturn all that. It will ride roughshod over provisions of the Constitution, and it is very specific that there is no judicial review or pronouncement which will declare any provision of the Constitution to be unconstitutional. That was what was precisely done here. You are saying this one is unconstitutional. Let us fix
Yet
it.
it's in the Constitution.
It is in the Constitution.
Let me throw a span in the works here, Wakili. Child born of a Muslim father out of wedlock, but
Yes.
it is determined
Yes.
that it was as a result of rape.
Same thing applies.
What happens?
Same thing applies. The child is born out of wedlock. You see, you'll always go back to the principle, whether it was rape, whether it was consensual, whether it was cohabitation, whether it is come we stay relationship, yeah? All of that is still a child born out of wedlock.
All right. We have a caller coming in. Is it Nixon or Dixon?
Peterson, I think.
Peterson. All right. Peterson from Nairobi. Good morning.
Good morning, Bua. How are you?
Very well. What's your question for Wakili Murshid?
The question is, she's saying that they should first recite Quran law for the child born out of the wedlock to not or inherit the property of the father. And the judge saw that the father, although he's wedded, has the wife in the wedlock as per the Quran. He also forgot that before reciting the law in Quran, he went outside the wedding and went pregnant with this innocent lady, got children, and comes back when the children who are in the wedlock inheriting the property, forgets that he did a mistake also not recite the Quran, gave birth to these kids, so they should have a right to inherit. He should not say that it's the Quran. He should recite when he also did a mistake not recite the Quran to get the kids out of the wedlock. So how can we do about that? Thank you.
All right. I think he's gotten your question.
I understood it halfway through because it is the same convoluted way of applying Christian Judeo interpretation to something that is essentially Islamic in character, whereas the other way around is also not possible. Can you imagine if this was a Muslim judge in the High Court and he told a Catholic, look, this idea of yours of monogamy, we're in a modern society now. We must read it to be polygamous, and you can have all the rights. You know, this place will be on fire. So I don't see how it's the other way around. We are supposed to say, no, it's cool.
Yeah,
it's okay.
I get that. But I think his question more so is that already by having a child out of wedlock, he was contradicting the Quran and against Islam. So then when it comes to inheritance, you know, he's already
continue the contradiction.
Continue the
Fast. Two wrongs will never make a right.
True.
How many of us see a red light here and still cross it? Yeah. Does it make us now say that
None of
we'll
us
cross
said,
all
none of
other
us
red lights
said no. Okay.
and we'll violate all the laws because I'm already a violator, I am outside the framework of the law? Religion is a trite thing. You have your whatever.
Right.
And it's not just applicable to you, it's applicable to the entire community, the entire nation of Muslims, which crosses all national. If I go to China today,
It will be the same thing.
It will be the
There's
same
a caller.
thing.
We don't want to lose him because we're almost at
Okay.
time. You said it's Hassan? Okay. Hassan from Nairobi, good morning. Do you have a question or comment around this conversation today?
Can you hear me?
Yes, we can hear you.
Okay, my question, good morning, Pastor Ole. My question is, what is the definition of a child in the Quran? And is there a specific verse from the Quran that talks about inheritance of the children born out of wedlock? Is there a specific verse in the Quran that talks about this issue that we are dealing with today in this morning? Yeah. So two questions of me. What is the definition of a child?
Yes.
As per the Quran? And is there a specific verse that God says or talks about the children born out of wedlock and their right, or then a specific verse in the Quran? Straight.
Okay, thank you,
Okay,
Hassan.
thank you.
Thank you.
who is a child? Do you have to go to the Quran to know who is a child? Any person who is born from a human being is a child. We are not here discussing who is a child. We are discussing which child is entitled to inherit property if the child is born out of wedlock. So I think these semantics, we try to deviate. But the other thing, is there a verse in the Quran? Multiple verses in the Quran. Don't tell me to bring them off it, because if I were to ask you, give me a verse in the Bible, you'll be as lost as I am. But they are there. There is an entire body of jurisprudence. If we want to fill this room, go to any Qadhi's court. Behind him will be volumes and volumes of jurisprudence on Islamic inheritance. And I welcome Hassan, just next door. Come to the Jamia Library. Yeah, we will be able to take you through all that. Thank you.
Yeah, we're just a minute to time. Some quick feedback. The Children Act, as read with the Bill of Rights in the Constitution, treats children equally. The aspect of illegitimacy was rendered null and void. That's Zephaniah. How do we establish a strong core without rubbing out the existing fundamentals? Hassan is actually here. He also asked the question.
Yes. The same one, yeah.
Yeah, the same one. What would it mean to write a new book and stop interpreting the old one? Does that mean we are right and just, or disobeying the old ways?
Right.
Yeah.
And I think he's already addressed the issue of illegitimacy. It's not the child that's illegitimate. You're born out of wedlock. Then the question would be now, as we close, what next? I know he's still under review with the Supreme Court. What next?
It's already a judgment.
We have
There's a judgment, actually, but it's
a
being-
14-day window by which any party can approach the Supreme Court in a bid to seek a review, because this matter raises fundamental issues around the Constitution. It is our hope, and we're very certain about it, that it needs to be admitted by the Supreme Court so that we have an opportunity of giving rise to proper law.
Okay.
Yes.
Sorry, we're just at time. We do understand that there's somebody who wants to just give their testimonial, I think, with regards to this case. Christopher, just if you can briefly tell us a little bit about what you want to bring to this conversation. Hello, Christopher? Christopher,
Naomba
unatupata?
kuwasilimia asubuhi ya leo. Mjambo.
Tuko salama, asante.
Nakusikia. Naomba kuwasilimia asubuhi ya leo. Mjambo.
Hatujambo. Aya basi, Christopher, punguza sauti ya TV yako.
Swali langu ni kidogo ni tofauti na mada mlionayo kwa mesa.
Christopher, tafadhali zima redio
Unakuwa
ama TV.
gani wa mtu akiwa Muislamu akifa na amesaliwa katika nyumba ambayo si ya Kiislamu, inakuwa ni ngumu kwao nyinyi kumzika kwa ile nyumba ambayo si ya Kiislamu? Naongea hivyo sababu nilikuwa na dada yangu ambaye ni Muislamu, alikuwa Muislamu kwa miaka yake yote akiwa hai, lakini amezaliwa kwa nyumba ambayo si ya Kiislamu kwetu. Wakati aliaga kama miaka 6 hivi iliyopita, alikuwa anaishi Isili. Ilikuwa vigumu sana sisi kumtoa tumpeleke nyumbani vile mamake alikuwa akitaka. Ikawa lazimika kwamba tumzike hapa Nairobi. Kwa hivyo tulikalamika sisi kumpeleka nyumbani, ingawa tulichukua Waislamu wakaenda kumzika. Mbona ikawa hivyo?
Okay.
It's good that it is not related to the matter at hand. Otherwise, I would have prepared myself adequately. But it's again the issue of personal status, personal law regarding a Muslim and the rights which you would have as your personal choice in becoming a Muslim.
Right. So
Just like
she's a Muslim. Yes. She was buried under Islamic law.
Islamic law.
Yes, I think maybe would there have been middle ground to have her buried? Anyway, no. Let's leave it at that. We're out of time. Yeah. But of course, we'll have a part 2 of this conversation. I think the issue of personal status is one we need to go into. So I will invite you back. But thank you so much.
I'll be most privileged to be here.
Asante. Murshid Abdalla, he is an advocate of the High Court. He is also a former commissioner of the National Police Service Commission and the Boundaries Commission. Of course, we'll be back in the next hour still discussing matters, not comedy, but matters in Etwaje, Saba Saba organization. Yes, with Njeru Kathangu. He was one of the organizers of the very first Saba Saba. Hashtag is Fixing the Nation NTV. Tupatane after the break.